Sounds. Thanks, Jose. Take it away, Sean.
All right. Thank you, everyone. Hi, everyone. My name is Sean McCormick, he, him. I'm a staff attorney with the Center for HIV Law and Policy. Next slide, please. I will get us started by just providing an overview of the trial court decision. Try to make this brief because I know the main focus will be on the new decision that came out from the Fifth Circuit. Next slide, please. So as a part of the Affordable Care Act, private insurers are required to cover certain preventive healthcare services. As a part of that mandate, the U.S. Preventive Services Task Force, or the Task Force, or PSTF, as I have abbreviated within this slide, is charged with providing evidence-based recommendations on certain items or services that fall within A or B categories. Next slide, please. I'll provide just a brief overview of the claims that the plaintiffs brought. This is, of course, just the latest attack on the ACA, a novel approach, but that has been around since the inception of the ACA. In this latest attack, the plaintiffs are challenging that the ACA preventive care requirement violates the Constitution as well as the Religious Freedom and Restoration Act, or RFRA. They specifically have constitutional claims under the Appointments Clause, non-delegation doctrine, and vesting clause. And their statutory argument is that the pre-exposure prophylaxis coverage requirement, or PrEP requirement, violates the parties' rights under RFRA. Next slide, please. The plaintiffs are a set of 2 businesses and 6 individuals at the trial court level, at least. Braidwood Management provides health insurance to its employees, approximately 70 of them, through a self-insured plan. Notably, Braidwood has also challenged Title VII non-discrimination protections, which prohibit discrimination in the workplace based on sexual orientation and gender identity. Another business, Kelly Orthodontics, joined as a plaintiff, as well as 6 other private individuals. The district court judge, Reed O'Connor, was appointed by President George W. Bush, and he is known for his opposition to progressive policies such as the ACA. For example, some of his other significant decisions have invalidated federal non-discrimination provisions and other parts of the ACA. Next slide, please. In sum, though, Judge O'Connor ruled for most of the plaintiffs, finding that the appointment of the PSTF members, the task force members, violates the Appointments Clause, and that being required to cover PrEP violates the plaintiff's rights under RFRA. For this specific Appointments Clause claim, the Constitution establishes some of the procedures for appointing principal and inferior officers. The issue frequently litigated is whether the members are officers and whether they are inferior officers, because each of those have separate procedural requirements. You can go to the next slide, please. For this Appointments Clause claim, plaintiffs contend that the members of the task force, as well as ACIP, which is the immunization body that develops recommendations on immunizations, and HRSA, which is a body within Health and Human Services Department, were unconstitutionally appointed. They did not follow the procedures that were required by the Constitution. And Judge O'Connor, for the most part, did agree with the plaintiffs, but specifically on the issue of the task force appointments. Although the court found no violation for the appointments of the immunization body or HRSA members, it did rule that the members of the PSTF were unconstitutionally appointed. Despite only meeting sporadically and working only part-time, the court found that the task force members are in a continuing position. The court also found that they had significant authority that could not be checked by a higher authority. The court focused on authorizing position for the task force that stated recommendations, quote, made by such members shall be independent and, to the extent practicable, not subject to political pressure, end quote. The court then found that regardless of whether they were inferior officers or not, the appointments were still unconstitutional for the way that they were made. You can go to the next slide. So for the RFRA claim, RFRA prohibits the government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability, such as the task force recommendations. This attack, as I mentioned, was squarely focused on the PrEP coverage requirement. Next slide, please. And plaintiffs contended that the PrEP coverage requirement caused them to be, quote, complicit in behaviors that were against their religion. The trial court agreed with the plaintiffs, and they relied heavily on the Supreme Court's precedent in Hobby Lobby, which was the contraceptive mandate case. They invalidated the PrEP coverage, and the court invalidated the PrEP coverage requirement. Judge O'Connor dismissed the compelling nature of the epidemic within this opinion, as well as the necessity of insurers providing comprehensive services to combat it. Next slide, please. Relying on the remedies that are available through the Administrative Procedures Act, or APA, the court issued an injunction that vacated all prior decisions made in response to the task force recommendations, as well as prohibited the future enforcement of the requirements implemented in response to these recommendations. This was a broad and universal injunction, but for the RFRA claim, it applied only to the prevailing plaintiffs. The RFRA ruling did not apply to the non-religious objectors, and it does not apply nationally to all health insurance coverage plans. The DOJ ended up filing an appeal ended up applying for a stay of the ruling, and the Fifth Circuit granted it. So while the appeal was ongoing, the nationwide injunction was not in effect. Next slide, please. So some of the just implications that were potentially in play by the trial court's decision is that this broad relief could have dramatically undermined coverage for preventive care, not just the PrEP requirement, but other preventive services such as lung cancer screenings, fluoride treatments, substance use disorder screening. And this would have secondary effects on coverage for government bodies coverage for plans that are created by government bodies outside of just the federal ACA requirements. We also know that in requiring these services, insurers reduced health disparities in access. These have particular benefits for folks who have been marginalized from the healthcare system, including Black and Latina folks, as well as LGBTQ folks, who face significant barriers caused by the way our health system is designed. It should also be noted that this interpretation and this use of RFRA has the potential for future uses to undermine progressive policies that expand access and promote justice. And that's what I have for the trial court. I'll pass it over to Liz.
Thanks, Sean. My name is Liz Kaplan. I'm the Director of Healthcare Access at the Center for Health Law and Policy Innovation. And I am just going to give a nutshell of what the Fifth Circuit decided on appeal so that you all have the takeaways up front. And then Jose is going to go into more in depth into the legal reasoning behind how the Fifth Circuit arrived at its decision. So let's go ahead to the next slide. So Sean touched on this briefly, but I want to make sure it's really clear to everybody on this call, the three different bodies that recommend preventive services that have to be covered under the ACA preventive care mandate. One, as Sean mentioned, is the U.S. Preventive Services Task Force, often shortened to USPSTF. They recommend the most services, that they have the largest group of recommendations. Anything that they give an A or B grade to has to be covered without cost sharing under the mandate. And their recommendations, of course, include PrEP as well as other preventive medications, screenings, counseling for many conditions, including different types of cancer, a lot of prenatal care recommendations, and various other things. The other two bodies are ACIP, which is responsible for recommending vaccines subject to adoption by the CDC, and HRSA, which convenes bodies of experts that recommend preventive services specifically for women and children. So if we can go to the next slide. So the reason that it's important to remember these three different agencies is because both the district court and the Fifth Circuit treated the three agencies differently. And unfortunately, U.S. Preventive Services Task Force is arguably the most important of the three, but also the one that the ruling is the most drastic for. So the Fifth Circuit said in its decision last Friday that the mandate in the ACA that almost all private insurers cover all US PSTF grade A and grade B services is unconstitutional. However, for procedural reasons specific to this case that Jose will get into later, the district court's nationwide injunction has been thrown out. So what that means, and if you get absolutely nothing else from this town hall, this is the point I want you to take away. And that is that for now, the court's relief is only for the plaintiffs who have shown standing in this case. That means basically people who work for Braidwood, people who work for Kelly Orthodontics, and the individual plaintiffs. There is no change to the ACA Preventive Services Task Force regarding USPSTF services for all other private insurers. So that's our number one takeaway from this afternoon. Jose will get into more of the sort of nitty-gritty about how the court arrived at that, but that is the main point from today. So if you can go to the next slide, please. So since that's the ruling on USPSTF, what's the ruling on ACIP and HRSA? And I think it's easier to understand what happened with ACIP and HRSA in relation to what happened to USPSTF. So the Fifth Circuit looked at USPSTF, looked at the statute and the HHS's secretary, authority over what USPSTF does and said, basically, there is no way that the secretary can actively supervise or ratify what they do. So there's no sort of process that the secretary could go through to adopt what USPSTF has recommended and thereby make their appointment as officers and their recommendations constitutionally mandated. However, the court said that the secretary has more authority over what ACIP and HRSA do, and therefore the secretary could theoretically ratify their recommendations, making the mandate constitutional as to them. But the court identified some legal questions as to whether the secretary has actually done that or not. So the case has been sent back to the district court to look at those open-ended legal questions and figure out whether the secretary has effectively ratified what ACIP and HRSA have already recommended. If you can go to the last slide. This is just information to connect with Chilpy. We put out a brief summary of this case, and we do sort of a bi-monthly newsletter with similar analysis of legal developments and regulatory developments, and there's information on how to sign up. But as I mentioned, Jose will go into more depth about how the court arrived at those final takeaways, and then we'll have some time, I think, for Q&A at the end.
Thanks, Liz. And can we go to the next slide? Perfect. So I just put in the chat a link to Lambda Legal's in-depth legal analysis. I also encourage you to read Chilpy's legal analysis. But just to get into a little bit of the nitty-gritty of the analysis, and then at the end we'll also talk about predictions. Next slide, please. All right, so Liz underscored this, but the main thing that we want folks to take away now is that the Preventative Services Task Force the Preventative Services mandate under the ACA is still in force for the vast majority of the rest of the nation. So it does not affect your work for now, but we need to remain vigilant. This is much better than expected, mainly because I was listening to oral arguments during Braidwood, and the judge, it seemed like they were just about to vacate the entire preventative services scheme, but luckily they did not, and we'll get into that. So Braidwood is a mixed bag. The court has really narrowed the ruling, thankfully, and that's what saved us for now. And the Preventative Services Task Force remain in place for most of the rest of the nation. And there's an issue that the court remanded back to to the lower trial court to consider, and we'll get into that. Next slide, please. All right, so just to reiterate, because I know the constitutional law and the appointments clause are this weird, arcane area of law, but the appointments clause says that there are the Constitution makes a distinction between two different kinds of people who work for the government. Principal officers of the United States, those are people like the president's cabinet. And those people have to be, like Sean said, nominated by the president, confirmed by the Senate. And there are people who are minor officers of the United States. The principal officers, they wield major powers under the United States laws. Like, for example, the Secretary of State has the ability to interface with other nations and come to agreements on behalf of the United States. But other minor officers who don't have that much power under the United States law, they could be appointed by folks like the Secretary of Health. Then that's totally fine. So here the main question and the main issue was whether the Preventative Services Task Force were principal officers or were they minor officers. And unfortunately, the Fifth Circuit ultimately ruled that they were principal officers of the United States, and therefore they were unconstitutionally appointed. Because they were not nominated by the president and confirmed by the Senate, but rather they were appointed by the Secretary of HHS. And the reason why the court ruled this is basically two main reasons. One is, like Liz said, the statute provides little to no supervisory control of the committee by HHS. And that is really the hallmark that the Fifth Circuit says to defining what an inferior officer is. Basically, they have to be controlled by a principal officer and have to be supervised by a principal officer to a sufficient extent in order to be truly considered a minor officer. Also, there's a provision in the ACA that insulates them as much as possible from political pressure. This makes sense because we want scientists and we want committees to make medically reasonable judgments without the influence of politicians, without the influence of outside factors. So the ACA attempted to insulate them as much as possible from this political influence. And so the judge said these two factors led them to conclude that the Preventative Services Task Force was unconstitutionally appointed because they were principal officers. Next slide, please. In contrast, the court analyzed the statutory scheme of the ACA for ASIP and HRSA and found that HHS does have control over ASIP and HRSA, that the secretary does ultimately have the authority to accept or reject ASIP and HRSA's recommendations. So even though the court didn't say this explicitly, the court more or less found that they were appointed properly under the appointments clause because they are minor officers of the United States, because they are supervised by Secretary Becerra. Next slide, please. All right, so here's the important part, the scope of remedy. So remember when Sean said that the plaintiffs only brought certain claims, constitutional claim, basically the appointments clause claim, the non-delegation claim, and the RFRA claim in their initial complaint. Well, under federal law, there's this law called the Administrative Procedure Act. It's a body of law that basically governs which federal agencies develop and issue regulations and rules, like, for example, the Preventative Services Task Force, ASIP and HRSA, and basically governs the process through which they create, promulgate, and issue rulings. The APA gives vacatur power to courts. So if a plaintiff brings a case under the APA, that then gives the court the power to issue a vacatur nullifying the agency action or decision for the entire nation. But here, the plaintiffs did not raise an APA claim, an Administrative Procedure Act claim, in their initial filings. In fact, they brought it way too late in the third round of summary judgment filings. And there's this concept under the federal rules of procedure that says there has to be fairness. You cannot raise a claim too late. It needs to be fully briefed. It needs to be fully developed. And because the claim was not raised at the initial stages, at the inception of the case, the court did not have proper jurisdiction or power under the APA because the issue wasn't brought before them in the first place. So as a result, because the court did not have the APA to be able to issue a national vacatur, they could still decide that the other agency, that the Preventative Services Task Force was unconstitutional. But the scope of remedy is solely limited to the plaintiffs themselves, not the entire nation. And I see folks are raising their hands and have questions. And again, we will take questions at the end. So thank you for that. Next slide, please. Yes, so that exactly what I said. Because they raised the APA claim too late, the court concluded the plaintiffs were not entitled to a vacatur that applied to the entire nation. It only applies to the plaintiffs. So HHS is prevented from mandating that Braidwood and all the other plaintiffs cover preventative care, but for the rest of the nation, it remains in full force. Next slide, please. All right, so for ACIP and HRSA, so during the course of litigation, Secretary Becerra issued a memo that ratified or accepted all the recommendations by ACIP and HRSA since 2010, since the ACA was passed. In theory, he did this to undermine the appointments clause at the trial level. He did this in 2021, I believe. And he did this to sort of bolster the argument at the trial level that that all the Preventative Services Task Force, ACIP and HRSA's recommendations were valid and constitutional. So plaintiffs claim that this memo did not follow the proper Administrative Act procedures. We're all familiar with the Administrative Act procedures. There has to be a notice of proposed rulemaking, there has to be notice and comment, and then it has to be formal adoption. And the plaintiffs say, hey, the secretary had to do this in order to ratify all of these recommendations by the Preventative Services Task Force. And so, because again, this was raised a bit later in the claim, what the Fifth Circuit did was they remanded this question back to the trial court to determine whether the secretary had to engage in this process and whether he ratified ACIP and HRSA's recommendations lawfully under the Administrative Procedure Act. Next slide, please. So I'm less worried about this ruling as opposed to the Preventative Services Task Force ruling. Even in the worst case scenario where the lower court finds the recommendations did not follow the Administrative Procedure Act, did not follow the proper procedures, I believe the ruling would still only be narrowly tailored to the plaintiffs. And even in the worst case scenario where where somehow the court does find it applies nationally, then the secretary could follow the proper procedures under the APA, mainly doing a notice of proposed rulemaking, notice of comment, then adoption of the rules to subsequently adopt the recommendations by ACIP and HRSA. Next slide, please. So we have to remain vigilant to preserve PrEP access to preventative care. So we've averted an immediate national crisis for now. Instead, there is a ticking time bomb. What just has to happen now is a plaintiff has to bring a case, this time with the proper claims under the Administrative Procedure Act, and they have this ruling from the Fifth Circuit that says the Preventative Services Task Force is unconstitutional. So half of their work is done. So these new plaintiffs have to do is bring a new case with the proper claims that would allow the court to issue a national vacatur. And I have no doubt the Fifth Circuit will not hesitate in issuing a national vacatur because, like I said, in the prior oral arguments, the judges kept on saying, why should we not apply a national vacatur? That is the default rule. Why should we not do this? So they're already primed to issue this type of national injunction, but they are precluded for now because they didn't do it, because plaintiffs didn't do it properly. But if there is a plaintiff who does do it properly, then the Fifth Circuit will issue a national injunction, a vacatur. And in my opinion, this is it's almost certainly likely, it's an almost certainty that this will happen in the future, that a new case will be filed with the proper claims, this time allowing the courts to issue this national injunction. So good news for now, no national healthcare crisis, ticking time bomb in the future is our prediction. And with that, I'm going to stop recording to do Q&A because we're happy to answer some off the record stuff. But let me stop the recording.